My ladies, my lord, can I pick up some of the more important background CGK? And so I'd like to go to the judgment if I can, and so that's tab 3 in the core bundle, and pick it up at the section beginning at paragraph 22, so that's page 40 of the bundle. This is the section dealing with the CGK as regards clinical trials and preclinical tests. It's dealt with by the judge under the heading clinical trials from paragraph 22, but he starts by referring to the preclinical tests, which may, if successful, lead to clinical trials. And as the judge refers to here, they can involve tests on animals. And can I just pause to consider that aspect? In the context we're concerned with, one can obviously do equivalent tests that we may contemplate on a human in an animal too. And I'm going to elaborate a bit more shortly, but to give you an example, you can administer a drug to an animal, in this case we were concerned with rats and rabbits, and take blood samples in just the same way at particular times and see the level of the drug in the blood and what effect it has had on, say, factor 10A activity or the ability of the blood to coagulate. And the point I'm trying to get to across to my ladies and my lord is that there's a parallel series of tests. One can do in animals what one anticipates one would do in humans. Of course, you do it in animals first before you then just make the decision to go ahead and do it, but you're doing a similar thing. Now, when it comes to tests in people, clinical trials, they're conventionally carried out in the 3 phases that my friend has already touched on, and the judge explains in para 24. And as my friend has said, phase 1 is typically healthy people, and at the priority date that was healthy young males. And you don't get to put it into a patient properly so called, i.e. someone with a disease, or in our case someone with a risk of developing thrombi until phase 2. And my friend's already made that point, and I'm just touching on it now because it is an important feature that my ladies and my lord will need to keep in mind to appreciate the arguments that were being advanced before the judge. Now, in phase 2, one typically looks at a range of doses and frequencies. The numbers of people involved are likely larger than phase 1, but still a relatively small scale.
Are you saying this as a general statement or specific to the facts of this case?
No, that's specifically, as a general statement as to how phase 2 generally works. You're putting it into patients for the first time, hopefully to see the most promising dose regimen or regimens to take to the larger scale phase 3 studies, which is where the efficacy is to be determined in a statistically significant way. Phase 1 and phase 2 are not directed to establishing statistically significant results. And my ladies and my lord would have seen our skeleton at para 68, where we set out the evidence of Professor Maibom accepting that both the patent and the prior art, which are of course examples of phase 2 and phase 1, the patent is phase 2, both of them he wouldn't take issue with. They're both in the same boat, and he wouldn't object to either of them on the grounds of a lack of a statistical analysis. Now, as you will have gathered from my friend's submissions and from a study of the judgment, our case is about that transition between phase 1 and phase 2. So it's about what is obvious to take forward to patients for the first time, having regard to the data that had been obtained up to then. So in the preclinical studies, including animal studies, and importantly the phase 1 results. And
well, the short point is, and it is a very short point, it is that when you are approaching stage 2, you have to consider vulnerability in a way you simply don't on 1.
Well, it's more than that, my lady, but you're right about that, because the patients are more vulnerable than the healthy young males. But actually, and I'm going to come on and elaborate this, what you're trying to show, the antithrombotic effect, is actually conceptually a different thing to an anticoagulant effect.
Yeah.
And so you can't actually show it until you put it in a patient, unless you have a case where you have correlation between what you see in the PD assays and clinical efficacy. But that wasn't this case. So it's a little bit more than the point that my lady put to me. And it's because you can't actually show what you're going to try and see
Can I also ask, you've emphasised animal experiments. Did the posters we were taken to were reflecting phase 1 data,
Indeed,
weren't
indeed,
they? Not,
yeah.
we haven't been taken to any animal-related data.
No, I'm going to show you. Let me tell you why I'd emphasise that. I'm going to shortly come to a point that we made in our skeleton, which was part of the body of the evidence about the importance of pharmacodynamic PD evidence,
Right.
in that there's actually a progression down the line from existence of the drug in the body, PK, to different PD parameters, to then hoping that you see the clinical effect. And the reason I've emphasised that there's a parallel is because I'm going to show you some evidence that establishes that progression, but also establishes that it had been shown in animals.
Okay, thank you. Thank you.
Now, I think I was just at the point of addressing this difference between pharmacokinetic and pharmacodynamic data that my friend introduced and described. And we're all agreed that the key pharmacokinetic parameter, PK, is the half-life of the drug, and he explained it to my ladies and my lord that it's the time for half of the drug to be cleared from the body. So if you just stop and think about that, if you've got, say, a level that's equivalent to 100 milligrams in the blood, whatever that concentration is, that will halve in a period, say it's 12 hours. Then one has a concentration equating to 50 milligrams in the blood, and 12 hours later, assuming no further drug is taken, it will be the concentration equating to 25 milligrams in the blood. And the point I just want my ladies and my lord to note there, it's an exponential decay. It's not a linear decay of losing 50 milligrams every period. You're losing half of what you've got left.
Is that always the case?
Well, that's the definition of half-life.
Okay.
I think what you're asking me is it possible for half-life to vary as the level changes?
Yeah.
And I can't tell you.
Okay, but
I
for
think that's
present purposes, one assumes what you say is
yes,
correct.
exactly. That's and so that's why you're going to expect an exponential decay rather than a linear straight line. Now, as my friend introduced and explained, the PD parameters are different in the sense that they're actually measuring the drug's effect on a biological marker in the body and how that may vary over time. And one does it as my friend foreshadowed. You take a sample from either an animal or a person if it's phase 1 clinical test, the healthy person, and then you measure that biomarker in the sample corresponding to the particular point in time. So if you've given a person a dose of X milligrams either once or twice a day, at particular times in the day you can take the blood and measure the thing you're looking at. And in this case, there are two in particular to have in mind. First is factor 10A activity, or more precisely, inhibition of it. And one would hope and expect that over time, the presence of a factor 10A inhibitor will have an inhibiting effect on factor 10A in the person's blood. That's why you're doing it. You're putting it in, and then you're measuring to see whether you're getting that. And you can measure that over time when a person's been given a particular dosing regimen. And if you achieve an inhibiting effect on factor 10A, one hopes and expects that that translates to an effect on the blood's ability to clot, what we call the anticoagulant effect. And so you can also, with the samples you measure whether the blood clots. And there is this progression that I just foreshadowed with my lady from PK, simply measuring how much of the drug is actually in the body over time, to PD parameters, first inhibiting factor 10A, that's the first one in line, and then that effect translating to a measurable effect on blood coagulation, that's the second one. Now, as my friend emphasised, the judge found in paragraph 27 that in fact there may or may not be a correlation as to the rate of decay, so the half-lives for PK and the PD parameter that you're measuring. That's the finding that my friend took you to at paragraph 27 at the bottom of page 40. Can we move on to paragraph 29 in the judgment? And here, my ladies and my lord, can see the judge explaining two things about the transition from phase 1 to phase 2. He's explaining that the cohort recruited will have the condition to be treated, a point that I've already foreshadowed. And in this particular case, it was all agreed that what you would be doing is looking for people that would be having knee or hip replacement surgery, because those people are vulnerable to VTE, that's venous thromboembolism. So if you put it in them and then you keep an eye on them, you can see whether you've got a low incidence of thrombi. The second thing that the judge describes here is that the dosage and frequency of administration will be informed by the results of the phase 1 trial. And that's an important finding he made. We'll come back to it because it obviously includes PD data, and there was a big fight about whether you'd just be looking at PK as the paramount thing or whether you'd be looking across the board. Now, if we can move forward in the judgment to paragraph 33, we can pick it up where the judge has just finished. So I've jumped over the long paragraphs where he's described each of the individual assays, but he's just finished explaining a series of different PD assays that have been developed to measure the anticoagulant effect. And he mentions something that I've already explained, that you take successive blood samples and see how that changes over a period of time. But this is the introduction to paragraph 34, which addresses another important point. And the point is that one cannot simply take the fact that a particular assay gives a particular measurement, so a particular way of measuring anticoagulant effect gives you a particular number. You can't take any of those as saying, seeing that establishes that you'll guarantee as a predictor of efficacy or safety for a direct factor Xa inhibitor. And that is the point about the last link in the chain. You don't know at this stage. You see the other things that I've been talking about. You may see the anti-factor Xa effect, the anticoagulant effect, but you don't know until you've actually done it in patients that you're actually going to see the antithrombotic effect. And what that point is, and what the judge is addressing here, is the conceptual difference between anticoagulant effect on the one hand and the actual clinical effect. And that's a point that we sought to explain, for my ladies and my lord, in our skeleton in some detail at paragraph 61. You may remember it. And just to re-emphasise, the anticoagulant effect is a PD measurement that you can see in healthy volunteers, but actually seeing that translate into an antithrombotic effect, the actual reduction in the formation of thrombi in patients susceptible to them, what you're looking at, is different, and that's what you're doing and looking for in phase 2. That is it, unless you've already established that one of the PD assays guarantees that you're going to get it. The jargon is that it correlates. But in cases where you don't have that, and we didn't here, you just have to look at the PD and use it as a guide. Paragraph 34 really addresses that very last point I've just made. The judge says, nonetheless, this lack of being able to use it as a correlated assay, that's the PD assays, were considered useful enough indicators to actually use them in phase 1. What the judge is explaining here is the point of using them, where you've got healthy volunteers, so you've got information that's useful enough from the phase 1 to then go forward. And actually, para 35 reiterates the point about not knowing for sure when you're going forward that you're going to translate to an antithrombotic effect. And in my note, I'm now about to make the point that I think I've already made to my lady. It's the last link that this case is all about in humans, that last link in the progression from PK half-life through to PD data to actually detecting the clinical effect. And we've referred to that progression in paras 64 to 67 of our skeleton. And if I can I just show you some cross-examination of my friend's expert, which hopefully makes the point very clear for my ladies and my lords. It's Professor Crowther, so supplemental bundle, tab 17, page 156. That's of the bundle. It's 2 or 3 pages of transcript, so it's relatively long, but I hope it makes it absolutely clear for you. Can we pick it up at page 334 of the transcript at line 17? And you see me telling the professor that I want to see if the picture I had as to the various parameters fitting together was fair, and I identify the progressively linked picture, and that the first thing is the simple issue of the presence or level of the drug in the body. He agrees at line 24. And at line 2 of page 335, that the PK parameter can be measured over time, and obviously what we're measuring relates to a specific dose. That's line 8 of page 335. And I identify the next thing down the line, what we're interested the drug to have an effect on, in this case inhibiting factor 10A, and he agrees at line 14. And he agrees you want that effect to have an effect on coagulation, an anticoagulation effect, that's line 17. And then he agrees with the progression put at line 18 to 23, you're wanting to introduce factor 10A inhibition from the presence of the drug. And then the next thing down the line is that you believe you'll achieve anticoagulant effect by factor 10A inhibition. And then line 24 over to the top of the next page, page 336, line 12, he agrees these are the 2 PD parameters we look at. The first link in the chain is does the presence of the drug at levels for this dose achieve inhibition of factor 10A? What does that look like over time? And then the next link is what factor 10A inhibition causes, a measure of anticoagulation. And there's a wrinkle you see in the transcript if one's looking at something more complicated like the heparins, but for our simple case he agrees at line 12. And then lines 13 to line 2 of page 337, he's agreeing that the last link in the chain, the next thing down the line from the PD effect of anticoagulant effect, is whether there's actually an effect on thrombi formation. And we see particular agreement that this is the thing we're ultimately interested in. It's line 23 on 336. Now, before we put it away, I'm not going to ask you to read it now, but I told my lady that the evidence also established that all the links have been done for animals, and it was only the last link for people. That is the passage that carries on from that. So it's 337, line 3, through to 338, line 24. It had been done. You can do models such as the shunt model that you will have read about in this case to actually get the thrombotic effect in animals. So the whole chain had been established in animals, and in humans the first 3 had been shown. But what had not been done, at least... Sorry,
it's all been shown for animals for this drug?
For this drug, yeah.
But not on this dosage necessarily?
No, what you show is that but obviously a rabbit has a very different dose. Yeah, absolutely. But what you are showing is that the drug is doing what you want it to do down the chain. And the point of these tests all the way along is not only to have an idea of what dosage is to use for the next stage of the test, but also what you're trying to show is that you're getting what you want to see.
Okay.
But my lady's absolutely right. I hope you didn't understand me as saying that a once-a-day dose for a rabbit had been shown.
No, you're not making a point about once daily dosing.
No,
for animals.
I'm talking about.
I said dosage. I meant frequency. Actually.
Yeah, I understood what.
Yeah.
I'm not making a point about a specific dose. I'm making a point about what the bigger purpose of these studies are, as to what to establish, and how you do it, and how you're doing it progressively. And the reason I'm emphasising that is because you've got confidence that the fact that you finish the chain in animals by doing the same type of thing. And then ultimately, you're looking at the information that you've got on the next closest link up the chain. And that's why the PD data is so important. That's what the fight was about between the experts, whether you're looking just at the PK data or whether you're looking as part of the picture to the PD data. Now, can we go back to the judgment and pick it up at para 159? This is another section directed to the common general knowledge, but this is that which relates most specifically to the transition from phase 1 to phase 2. So it's still common general knowledge. He's coming back to the common general knowledge, but that's what he's addressing here. And para 160 on page 63 of the bundle explains that both PK and PD assays are informative about likely clinical efficacy, but not unerringly predictive. So that's the point in that you can't say I've got a number so I know for sure it's going to work, but they're both informative. They both give some useful information. And the following paragraphs address a dispute between the respective experts as to where the importance would be attached that I've just foreshadowed with my lady. From the start of para 161, Bayer's side suggested PK, i.e. half-life, would be considered paramount. Now, it was common ground that half-life was an important piece of information, and the judge sets out the essence of that by reference to the cross-examination of my expert, Professor Wilkins, in para 162. That was common ground, but the real fight was whether you looked further. And the judge goes on to explain two important points in 163. The first point is whether, having regard to when you're just looking at the half-life, you decide to dose once per half-life as a universal guide. Now, Bayer were arguing that, although I have to say, I confess I never really understood why they were being able to say that it was so prescriptive, because their own evidence wasn't that prescriptive, even when you're just looking at half-life. But the second important point in para 163 is that there are guides to the appropriate regimen other than half-life. And PD data is obviously what the judge has in mind. Half-life is an important contributory guide, but as the judge explains here, there are guides other than that. And this is part and parcel of what the judge is holding, where he prefers the claimants' experts to Bayer's, who wanted to focus only on the half-life. Now, para 164 covers another important point as to what the purpose is in phase 2, to establish the optimum dose to take forward in phase 3. And that involves using a range of dose regimens. There had been disagreement about this, but Professor Crowther had agreed it in cross-examination, as the judge recorded. Obviously, no dose that would put a patient at risk would be used, as the judge records, but subject to that, a range would be used, and it would be expected that some would turn out to be less effective than others. The fact that they're not all the same doesn't mean that you've put a patient at acceptable risk. And just to give my ladies and my lord a feel for the range that you would expect to include, in our skeleton, paragraph 19, we give you the reference to Professor Crowther agreeing that the range covered by the patent was typical of the kind of thing that you would expect to see. And as my ladies and my lord know, that covers a 12-fold dose range at twice a day. It's 2.5 milligrams to 30 milligrams twice a day. And none of those would be included if it thought the patients would be put at unacceptable risk. None of them. And just pausing there to think about that, increasing the dose by a factor of 12 from 2.5 to 30 in the twice-a-day arms means that you're contemplating just 2.5 milligrams being enough if you give it every 12 hours. It's not an unacceptable risk to be taking. And the reason I'm just highlighting that for my ladies and my lord is that you can of course see that instead of only varying the dose and keeping it all twice a day, you could vary the dose frequency to achieve the drug levels falling to about the same level that 2.5 milligrams will fall to in 12 hours, but over 24 hours. Where one is willing to vary dose by 12-fold at the same twice-a-day frequency, you can see that you could think about the lower levels being achieved, those that the lower doses provide, if you went to one of the higher doses just once a day. And that's a puzzle that we on our side of the court have never understood. Why is it supposedly okay for a wide range of doses twice a day, including very low doses, but unacceptably risky for significantly higher doses once a day, still in the range that you're prepared to give twice a day? What I have in mind is the 30. Prepared to give 30 twice a day, prepared to go as low as 2.5 twice a day. What is it? And in fact, that is the very same point that was made in the South African judgment in one of the passages quoted by the judge. You'll note it's the point at para 323 of the quote set out in para 155 of our judgment. So it's page 62 of the bundle, and the paragraph 323 is from the South African judgment. What I'm asking my ladies and my lord to just pause and think about here and to really emphasise for you is that the reason I'm raising it now is to highlight that what you actually have here are two levers to pull in the sense of what can you adjust. Two things to vary: individual dose and dosing frequency. And that sets me up to explain what became known as the ribbon at the trial that my friend has already touched on. And the judge deals with this at para 169. And the first thing that I am going to really make sure that I emphasise is that the ribbon is conceptually different to the therapeutic window. My friend orally explained it in a satisfactory way, but there are parts of his skeleton where he muddles them up. And I'll explain shortly how the two relate, but I want to make sure that you understand that the ribbon is not the therapeutic window. The ribbon is the band occupied by the peak to trough trace that a particular dosing regimen, so it's specific to a dosing regimen, the trace that it will follow on a plot of drug plasma levels against time when at steady state. And that's an important qualification. And the judge explains that at 169. So it's the area that is kind of occupied by the drug at that specific dosage regimen on the plasma plot. And can my ladies and my lord take my skeleton, because we've reproduced all three of the relevant diagrams to have in mind here. And the first is Professor Mybone's, which we reproduce at paragraph 48 of our skeleton. And that shows two different dosing regimens. In fact, here, actually starting from when you first put it in the patient, you can see it goes down to 0 at the 0. So that it's only the right-hand end that's actually steady state. It's the right hand, or probably the two-thirds to the right-hand side that you need to be worried about. And what Professor Mybone has done is to show two different regimens, but where he's kept the total daily dose the same. One regimen gives it all in one dose, that's the blue, and the red line is split up so you get a third of it 3 times a day. And not surprisingly, what you see is the greater fluctuation, bigger peak to trough variation on the blue regimen, where the patient is topped up less frequently, but in bigger amounts. In terms of the levers that you can pull to make the changes, both are being pulled here. You're doing both. The size of the dose, the individual dose, is changing, and the frequency too, in a sense, in equal and opposite directions to maintain the same overall daily dose. Now, the second diagram that is important to understand is X5. The judge also reproduced, and we've put it over the page. So it's paragraph 50 of our skeleton. But what we've also done is reproduce the page from the exhibit, the textbook that was in evidence that it came from, that we blew it up from, so you can see. And it's the Rowland and Tozer standard text that my friend mentioned on another point. And this diagram is to show the effect of just changing one of the variables. The size of the dose is kept the same, but the frequency is changed. And we took the traces from the right-hand side and blew them up because it's steady state that we're interested in. And you can see in the legend that of the full picture that it's 100 milligrams in this particular example. And so we labelled it 100 milligrams, the size of the dose, traces A and B. And what you can see from the legend, what you can see is that the two regimens settle at different heights on the plot. But the point we made by this, and was agreed by Professor Mybone, was that when the individual doses are the same and the frequency is changed, the peak to trough variation is actually the same. It is determined only by the size of the individual dose. The trace will settle higher on the graph, to be sure. And that is recorded by the judge at 175 of the judgment. The same dose, however often given, will give the same peak to trough difference. In other words, exactly the same width of ribbon. Trace A and trace B occupy the same size area in the plot, it's just they're in different positions. A is higher than B. And just as an aside, the point that the judge made about the rate of incline being different between A and B, it wasn't material to the point being made, and he accepted the points that mattered. But you may recall he was puzzled by the fact that the rate of decline on trace A and B were different if it's the same drug with the same half-life. He mentioned that at paragraph 174, correctly said it wasn't explored, and he took it no further. I think what he's done is overlooked the fact that the half-life is a power relationship, not a linear one. And so the gradient of the curve is not the same at different heights of the plot, even though the half-life is the same, as I explained to my ladies and my lord just a little bit a while ago. And in fact, you can see exactly the same thing in Professor Mybone's own graph. If you look back at paragraph 48 of our skeleton, on the blue line, you can see that the line it's not straight, it comes down and decays. And I think that's what was puzzling the judge. But the important thing that it's accepted, because the witness did, is that the ribbon is exactly the same size if the individual dose is. Now, what these combined diagrams show is that a thinner ribbon can be achieved with smaller doses, but the same size ribbon is achieved if the dose is the same, regardless of the frequency you administer it. If you change the frequency while keeping the dose the same, you alter where on the plot it settles, as we see in that diagram. And just to foreshadow why I'm labouring this point, The fight between the experts as to what the obvious dosing regimens were was 30 milligrams once a day or 30 milligrams twice a day. Same size ribbon. Now,
so put it another way, what you have on paragraph 48 of your skeleton is not the appropriate.
not the right question. Not
comparative.
Yeah, absolutely. And I'm going to get to it. I'm going to show you that there were 3 issues where there was a potential risk that was being put forward. The size of the ribbon, which Mr. Waugh really went for, and I was rather surprised Mr. Purvis did, because his expert agreed that there wasn't a difference between them on that. There is a point that does matter, and I'll come to explain what it is, but it's not that. Before we get there, can I address the therapeutic window? The judge addressed that early in the judgment of para 17 and 18 to explain it. And the key thing to note is something that my friend, I think, has already fairly accepted. That it's the last sentence of 18. It's never possible to know in advance where it lies and how wide it will turn out to be. Sorry, I've asked you to go back to 18, yes. So right at the end, in advance, you don't know where it lies or how wide it will turn out to be. And he makes that same point more specifically in the context that we're concerned with, approaching phase 2, at paragraph 120 of the judgment. He's making the same point there in the context of what we're most specifically concerned with. And going back to Professor Myboom's diagram at paragraph 48 of our skeleton, it's been drawn in, but my ladies and my lords shouldn't think that the skilled team actually knows where on the graph it is or how wide or narrow it is. And there's a danger looking at Professor Myboom's drawing that one thinks that you know that it's there and you're making a selection of a dosing regimen, aiming for it in that knowledge. That's not the picture at all. The point of the professor in including it was to illustrate the point that he was making by reference to it, that the judge had set out at para 169 of the judgment. The suggestion that was being made was that with no knowledge of the size of the therapeutic window, so it's size, not position, the skilled team would aim for a relatively small peak to trough difference, because you've got a better chance of fitting in the window. That's one point, and I don't take issue with it. But it is convenient at this stage to just pause and note that it's just one of a trio of points that were being made. And as I just foreshadowed, it's the one that was pressed most strongly by Mr. Waugh. But there were 3, and indeed this one turned out to be a complete red herring. All 3 points are related to the therapeutic window, but they're separate. And we identify them at paragraph 47 of our skeleton. And actually the other 2 relate more to its position. The reference is actually Professor Myboom's cross-examination that I want to show you if I can briefly. So it's the reference at footnote 25 in our skeleton. So it's supplemental bundle, tab 19, page 223. Page 752 of the transcript. This is where I identify with him the points I understood that were being made. And if we pick it up at line 9, we see we're on the size of the peak to trough variation. So that's the point made by reference to this diagram. Then at line 19, I say to him that I think there are other points in play and that I'm going to identify the points I thought were in play. The first is that particular point, the size of the variation between peak and trough. But there are two further points being advanced. I identified another consideration I understood as being raised is the position of that the peak reaches, so the absolute value of the peak, and that's because of going too high with the peak to go over the top of the therapeutic window. So I'm now at the top of page 753 of the transcript, and through to line 10, I'm asking him if that's another point being advanced, and he said yes. And the third consideration was identified from line 11, and that's if the value at the trough goes so low as to fall below the lower bound of the therapeutic window. You see through to line 20 where he agrees that's the third issue or question. If the value of the trough descends too much. These are the 3 points that were raised. And the vice of that diagram, Professor Mybaum's diagram, is that it leads you to think that the choice that the skilled team is making is constrained as how to split up a fixed total daily dose. The tendency is to look at it and to think the choice is between blue and red, having already decided a fixed daily dose. But as we pointed out at paragraph 49 and 50 of our skeleton, that is not the position at all. The dosage regimens that Professor Mybaum put forward, which were Bayer's fallback position, they said you wouldn't do anything at all, but if you do, this is what's obvious. They were 2 different doses at twice a day. So different daily doses, and they included 30 milligrams twice a day. So way higher as a total daily dose than the 30 milligrams once a day, identified by both of my experts.
So one was 30 and was the other one higher than that?
Well, they were both, mine was 30 once a day. Oh, you mean his?
His too.
Oh, I apologise. The other was 20 twice a day, I believe. Yes. I was particularly interested in the 30 because of the fact that he was happy that a ribbon of 30 milligrams wasn't an unacceptable risk. So that's why I was interested in that with him. So his two doses were 20 and 30 twice a day. And my experts had both identified 30 once a day. But of course, the point I've already foreshadowed, 30 is the size of the individual dose. So the individual ribbon size is the same. So in terms of risk, in terms of their case as to what was obvious, at least as the fallback, on that particular issue, their risk was the same. And I explored the 3 issues that Bayer were advancing, the ones we'd just been through, to compare the 30 milligrams twice a day dose with the 30 milligrams once a day dose, to see who was the more risky on all of those issues. Because of course you don't know where the window is. Which is the riskier for these particular issues? And the principal point that was advanced, the one that my friend tried to resurrect this morning, the peak to trough variation, as I've said, they're the same, so there's no difference in risk. The risk of bleeding, where you go too high, the peak, you've seen that the extra frequency means it goes higher on the plot. So theirs is worse. Professor Mybaum's 30 milligrams twice a day will settle higher, and so on that second issue, it's actually riskier than what we were putting forward. And the whole thing came down to whether there was a perception that there would be an unacceptable risk that the trough would drop too low, i.e. that the trough of 30 milligrams once a day would drop so low so that it was below the therapeutic level at those trough points. I'm not going to go through it now, but for your note, it was the next couple of pages after the bit that we just looked at in the transcript. So it's page 753 through to 758, where we covered those 3 points. The only one of which it could be said there was any point about the claimant's proposed 30 once a day taking a greater risk than them was the level of the trough. And I've taken some time to explain that because it's an important point of context to understand what the rival contentions were before the judge. Once Bayer didn't support the first line of defence in the evidence that you wouldn't go forward at all, the fight was between the doses my client's experts identified, both of which had specifically included that 30 milligrams once a day, and if it was included, that hits the claim. The fight was about that and those Professor Maibohm identified. I don't think Professor Kramer identified anything at all. Professor Maibohm identified those two 20 milligrams twice, 20 and 30 milligrams twice a day. And that's why the case boils down to that bottom point. Is it enough for the troughs to be up so that you don't have an unacceptable risk of thrombi forming? It's all about that. And before I turn to actually address the criticisms of the judgment, can I just canter through the rest of the judgment and highlight a few of the key findings that the judge made in the latter stages of it. We were on section 170 to 177, where we were looking, albeit by reference to my depictions in the skeleton, to the bit where he was dealing with these diagrams, where the judge made the finding, where the paragraph I want to draw attention to in this section is 177. The judge made a finding that the point about the ribbon, width of the ribbon being smaller if you go to smaller doses, one we've just been describing, he's just been explaining in 176, that does not decide the principal question whether on the evidence any once-a-day dose contemplated by the skilled team would have been thought likely to be both safe and effective. It's an important finding, and he's obviously right about that, not least because of what I've just been explaining, the rival counsel putting forward dosage regimens where the ribbon was exactly the same size. Yet the submissions that you heard this morning seem to be predicated on the basis that somehow this ribbon thing was the answer to the question, the answer to the case, and the reason that they were right. Now, can I pick up a few other key findings? If we go to paragraph 185, the judge is making a finding that figure 4 in Harder also shows residual activity at 24 hours for pit and picked. So that's on top of the big effect that you can see in the ETP, the graph that he shows on the bigger, on the page before. It's not just that. On top of that, you can see something in figure 4 of Harder. So that's obviously in addition to the ETP data that was specifically called out in the 4th bullet point. Can I also draw attention to paragraphs 193 and 194 in relation to the Kibitzer posters, related to the PD data in the Kibitzer posters? 193 relates to evidence from Professors Hirsch and Wilkins that the skilled team would notice inhibition of factor 10A remained elevated at 24 hours or the 30 and 40 milligram doses. They weren't challenged. The judge says the same appears true of the PT assay. And paragraph 194 is also important. The point is Professor Mybourne made a carefully worded concession that Professors Hirsch and Wilkins were correct, which the judge finds they plainly were correct. It's important, particularly this paragraph, in the light of one of the arguments my friend is seeking to put forward on appeal. The point is the judge found it not helpful for the professor to be suggesting that the skilled pharmacologist would not know what levels of factor 10A inhibition was needed to be therapeutic. So the point about, well, I don't know what number I need to see, because that's exactly the kind of argument that is sought to be resurrected on his second alleged error, which my friend confirmed to me they are still running. He just ran out of time. And it's not a helpful way of looking at it. And the judge points out perfectly fairly that taken to its logical conclusion, that means none of the data, the PD data reported for factor 10 inhibition was much value. That last sentence is an important finding. Those in the field regarded such data as the best PD data they had to work with, and importantly, they believed it was of sufficient indicative value to be taken seriously. And the point that was being put forward by Bayer's witness was, well, I need to know the numbers, but that meant you wouldn't know the utility of any of this data. And just pausing here, my ladies and my lord, I'd add it's a rather bizarre argument for a party that's suggesting one looks only at half-life, because that doesn't even purport to tell you that anything about what you're getting from a particular level. You get a level in the blood, but you've got no idea what you should be achieving. Can I move forward to the business end of the judgment and just pick it up in the discussion part of it? I want to draw attention to 245, if I may. This is the discussion immediately after the section where the headline arguments have been set out, and just after the paragraphs where the judge referred to the ethics issues again, and the issues relating to the committee giving approval. And the important thing about para 245 is the judge makes it clear what question he's addressing as he moves on from these paragraphs. Whether the skilled team of the present case would have considered there was a reasonable expectation that a once-daily regimen using any chosen dose would be sufficiently safe by avoiding an unacceptable risk of thromboembolism during the course of the phase 2 trial. Have I missed it? Sorry. By avoiding an unacceptable risk of bleeding and also sufficiently effective by avoiding an unacceptable risk of thromboembolism during the course of the phase 2 trial. So I've transcribed that incorrectly. But the point I'm making is that he's obviously grappled with the ethics of this, but then when he gets to the end, he's saying, this is the question that I'm going to address. And he's looking at the skilled team's reasonable expectation of avoiding an unacceptable risk of the bleeding, which is the top end problem, and the embolism, which is the bottom end. And it's actually the bottom one that matters. And I can't see how my friend can criticise that at all. Paragraph 247 is the judge dealing with the primary contention in Bayer's evidence that the team would abandon the idea of phase 2 altogether. That's the one that Mr. Ward didn't support. And the end of the paragraph refers to the fallback position as to what would be taken into phase 2. The end sentence about the claimant's experts, Professor Crowther and Mybourne, is important, that there was to some extent a determination to be negative. That was his view, that was his finding, having heard all of it. Not least probably because they had come along and said you wouldn't do anything at all. We're looking more detail later, but can I also just flag up para 252? That is the finding that the skilled team would have turned to look at the PD data. That is important given the argument about relying only on PK, half-life. And 254 is the judge's conclusion as to what the skilled team would conclude as to the statement in Harder on suitability for once a day, that it was a reasonable thing for them to have done.
Sorry, we're 254.
Four.
Thank you.
That is a conclusion on the facts, an important one. And the key conclusions in para 256 and 257, the views of Professor Hirsch and Wilkins were more realistic, specifically as to the 30 milligrams once a day. Including that would not have caused an unacceptable level of risk. That hits the claim, as the judge held in substance at para 258. Now, can I just deal with another point that rather took me by surprise this morning, before I move on to the specific criticisms that are identified in the skeleton. There was an attack on the judge's reliance on Professor Hirsch's evidence because the judge rejected a couple of things that the professor had suggested might be part of the common general knowledge. You remember that? And my friend was suggesting that meant that all of Professor Hirsch's evidence...
Yeah, and you say that's A, not in his grounds of appeal, and B, not in his skeleton argument.
I say that, and C... you're right, I say all of that, but they're really bad points in any event. I can nail one of them on what is in the bundle, and I can tell you what the answer is to the other one. The point on relying on heparins is nothing to do with the 30 milligrams once a day. Professor Hirsch had also suggested very much lower once a day doses and explained that his reason for that was because of heparins. So it's tab 11 of the supplemental bundle. It's paras 222 and 223. So it's page 101 and 102. And you can see in 222, if you go down to about the fifth line, he's explaining here what he would include and the range that he would include. He said 2.5 twice or 5 milligrams once a day, and then up to 30 milligrams once a day. So his 30 milligrams once a day is there, but also 5 milligrams once a day. And if you go to 223, you can see that the heparins was all about why he'd gone so low as 5 milligrams once a day. It's nothing to do with the 30 milligrams. And it's quite wrong for my friend to say that just because an additional point that Professor Hirsch advanced was rejected, that means the entirety of his evidence the judge should have rejected. It was a point that was specific to a much lower dose, which of course is not part of the case that's before my ladies and my lord. It's the 30 milligrams once a day, and that's the one that the judge accepted. The other point, I can tell you what the answer is. He suggested, in response to some evidence from Professor Mybaum saying that people would think that the therapeutic window was narrow, Professor Hirsch, in his reply report, took issue with that and said, we thought in quite measured terms, that you, if anything, you might think it's wide, and that caused Professor Mybaum to retract what he'd said in a third report. So it all fizzled out. But I suppose the evidence still left the judge with Professor Hirsch taking issue with the suggestion that it's narrow, saying that's not right. If anything, it might be wide. But that's not a fundamental premise of the basis upon which he put forward his evidence either. He was answering a point where it looked as if the other side were making a point that you had a particular expectation that it would be narrow or wide, and he was answering it. So, my lord, that's C and D on top of your A and B, but I do make those points as well. Can I turn to address the specific criticisms that my friend has levelled against the judge? I'm going to do it by following the structure in his skeleton rather than trying to follow his grounds.
Yeah, fine.
And so I'm going to start with the first alleged error, and that's the criticism directed to the judge's discussion of the ethics of the situation and the argument he was confronted with. And can I probably get into the details? Can I make what we say is a simple point, which my friend doesn't really have an answer? None of this debate actually affects the fact that the judge found as a fact that he preferred my client's experts and their evidence as to what the skilled team would do and want to include, specifically the 30 milligrams once a day. As I emphasised at the beginning of my submissions, that was put forward independently, both from the point of view of the clinician and the pharmacologist, without having seen the patent. This point doesn't actually touch that at all, nor does it face up to the fact that at para 245, as I just showed you, the judge expressly identified the question he was addressing in the key conclusions. It's expressly the reasonable expectation of success, in the sense of avoiding an unacceptable risk. That paragraph I have identified for my ladies and my lord a few minutes ago. And the reason the judge mentions the ethical dimension in his judgment is because of the peculiar nature of the inventive step that's being argued for in this case, specifically in the stark context of the prior art telling the skilled team that Rivaroxaban is suitable for once-a-day dosing. It's a pretty stark thing. And the essence of the argument was that even in that context, an express statement as to the drug's suitability for once a day, and even if the skilled team thought it likely that once a day was likely to work in the sense that the drug was indeed suitable for once a day dosing, the skilled team wouldn't include it in phase 2 because it was too risky, because you had to choose one or more specific once a day doses, and you might pick one which was not sufficiently efficacious to be safe. That was the very specific nature of the argument. It was a very unusual inventive step argument. And it was an argument that even looking at once a day that you otherwise thought would be something that would work, would be too risky. And it was my learned friend Mr. Wall, whilst trying to make that argument good, that he cross-examined Professor Wilkins on the Helsinki Declaration on Ethics. Now, I don't know whether the judge actually saw the point as being so tied to ethics before that cross-examination. He clearly says that it had occurred to him about the nature of the inventive step when he was reading in. But what Mr. Ward did, and if I can show you, it's in the supplemental bundle at tab 18, page 189, transcript 567.
Sorry, could I just have that page reference?
Yes, sorry, 189 of the bundle.
Thanks, that's
and,
fine.
And then we're looking at 567 in the transcript when we get there. Question at line 5, we have a copy of that. It's the Helsinki Declaration that Professor Wilkins had mentioned as part of the background. It had been included in his cross-examination bundle. And the thrust of the cross-examination is that long question at line 14 of 567, that in clinical trials on humans, the health of the patient is paramount at all times. Not really surprising, this stuff. And you see Professor Wilkins in agreement over to the top of page 568. He agrees, and he says it's not just the Helsinki Declaration, it's the heart of all medical research, including the European Clinical Trials Directive, Human Medicines Act, and the process by which ethics committees operate to put patient safety at the forefront. Now, just pausing there, what this shows, my ladies and my lord, is that everyone is operating to the same standard. And we'll see shortly that the judge, when considering the ethics committee, specifically mentions the likelihood that the reference to how the ethics committee approach things could be considered the same thing as the skilled team. And he's right about that. What the ethics committee is an independent body overseeing clinical research, making sure that the decisions are made are the right ones, but they're applying the same, not different standards. It's the same thing the medical professionals involved in the clinical research are working to, as that answer makes clear. And of course, at this stage of my submission, the point is that this consideration was being put forward by my friend's side as an important factor in the rather unusual inventive step argument. And indeed, in the context of the evidence here, it was the only barrier because of the fact that efficacy at the bottom of the window is, in this case, a safety issue. It's a safety issue, the point at the bottom, so that's the only thing that matters because it's the only one of the trio of points that matters. And it becomes the only issue because of a point that's emphasised by Bayer, that the action of the drug that is desired is a safety issue at both ends. If there's not enough effect, you might get thrombi, and also if there's too much, you get bleeding. As I've said, my ladies and my lord, what actually matters in this case is the thrombi forming. And as I foreshadowed, the whole argument being advanced was that because of a need for caution in phase 2, because of this particular issue, you just wouldn't do it. You would not take the risk. And that's why the judge referred to the ethics of the position. Now, my friend Skeleton seeks to articulate their criticism of the judge from para 28. But it's in fact worth referring to para 27 first, where the submission is made that the judge should have asked himself whether the skilled team would have had a reasonable expectation of success of the once-a-day dosing of Rivaroxaban, meaning whether it would give rise to a ribbon which fell within the therapeutic window. Well, my ladies and my lord, we say the substance of what he did was precisely that. It's just that the only part of that point that actually mattered was whether the troughs, i.e. the bottom of the ribbon, were above the bottom limit of the window because of the rival contentions. But he was asking that question, was there a reasonable expectation of efficacy so that the patients were not unacceptably at risk from the drug levels being too low? That's in substance what he did. That is what he identified that he was going to do in that paragraph 245 that I've just shown you. Now, my friend Skeleton goes on, this is para 29, and identifies where the key sections of the judgment starts. Para 119, and then he says the judge begins by what he says in para 124. So, my ladies and my lord will see my friends have ignored the paragraphs before 124. He doesn't begin there. If you look at the paragraphs before, you see what the judge is doing, precisely what they say he should have done. The substance of paras 120 through to 122 is the judge explaining the therapeutic window, which, as we covered earlier, you can't know before the phase 2 studies are conducted, nor can you know which dosing regimens will fall in it. That's the last sentence of the paragraphs. And that point is generally applicable. And by that I mean it's applicable to any frequency. It's applicable to the twice-a-day frequencies that were being put forward by my friend. And the judge goes on in para 121 to identify the specific issue that matters in this case, the risk of being too low, where doing that would risk harm to patients because, due to their invasive surgery or otherwise, they're vulnerable to clot formation. And if there was not sufficient inhibition, there was a risk of fatal embolism. And that actually mirrors what he was doing later in that paragraph 245. But he's identifying, in substance, the same thing at the border that actually matters. Precisely what Bayer said that he should have been focusing on. At least focusing on the individual one of those trio of points that actually matters as to that. And para 122 draws it together. This paragraph is also important because the judge is making it clear in this context, reasonable expectation of success would have amounted to a reasonable expectation that such a regimen would not put the welfare of patients in phase 2 at unacceptable risk. In my submission, the judge is specifically accepting the substance of the point Bayer is making in paragraph 27. Now, the judge then explains how he saw this particular argument compared to the usual case where there's no reasonable expectation of success. And that's para 123. And in those cases, as the judge explains, the skilled person labours under a conventional technical perception or prejudice that there's no reasonable expectation. And the inventor comes along and rejects that. What the judge is doing here is drawing attention to the fact that here the argument is different in nature. And as an aside, if anything, we say what he's describing is a higher hurdle. What Bayer was saying in substance was that the skilled team is frightened to even look for the doses that work, even if they had a reasonable expectation that some once-a-day doses would be satisfactory. And this was a key point in Bayer's argument. Mr. Waugh emphasised the difference between this kind of case and the tadalafil case that my lady's seen in the bundle for the first time. That's the Supreme Court case of activists in ICOS, where it was routine to look for the minimum dose. And in a memorable passage of my friend's closing, which regrettably hasn't been included in the bundle, he colourfully emphasised the point that the skilled team can routinely look for lower doses in that case, which was a case about a drug to treat erectile dysfunction. And he rather colourfully explained that there was no significant consequence of having it too low. He referred to it as being disappointing but not deadly. And he's right. But that was the nature of the argument, that, look, this isn't a tadalafil case where you think it's going to work, so you just look for the right dose. And the serious point being made was that one just you don't even use a dosing regimen if it's perceived it will put the patients at unacceptable risk. And here the judge explained the nature of that point being made in his paragraphs 124 and 125, not by repeating Mr. Waugh's amusing comparison, but by explaining the substance of it. This additional point that once-a-day doses would not be included for fear that one or other selected that you want to look at might not give high enough levels of the drug. And he's doing no more than reflecting the substance of the point that was being advanced on Bayer's argument. They were saying even if you perceive once-a-day doses reasonably likely to be satisfactory in the sense of one or more of them would be, you'd need to know for certain or near certain which ones beforehand to put them into phase 2 at all. So the argument is that it's not good enough to have an expectation of success for once-a-day dosing unless you also knew for certain or near certain, or however you want to describe knowing that you would only be including the specific once-a-day doses that didn't involve an unacceptable risk. And it's clear that in this case, the judge's view was that there would be no perceived technical barrier in the sense that you would perceive once-a-day likely to work. That's what he's referring to at the beginning of para 124, where he refers to no technical barrier in the present case. I emphasise those words. And he's clear in this paragraph to explain that he's not saying, as regards the present case, once a day dosing generally always likely to work.
Well, the focus of the criticism is the last sentence of 124, which it says amounts to an element of prejudgment of the issue.
Yes, well, I'm going to show you he's not. He's actually, what he's explaining there is the problem. The skeleton suggests that actually the prejudgment is the first sentence of 124. In that he's saying that because there's no evidence, and so the way they put the argument in the skeleton is that he said that you would perceive that once a day will work before you've even looked at the evidence. And what I'm going to submit is that he's actually foreshadowing a particular finding he makes later, and he's doing it to explain that there's a further point being taken, even if there's no technical barrier. It's being suggested that you wouldn't then go on and use any because you think that it's too risky anyway. The first sentence is not the focus of the explanation, but it is the premise that if you perceive that there isn't a technical barrier because you think once a day doses would work, it's not enough on Bayer's argument. Bayer was arguing that even so, unless you know for sure or near certainty, you still don't include them. And that's what the judge is describing here as the further point. One cannot simply choose a wide range of doses from very high to very low. Please note that he's talking about you can't pick a wide range. So you can't do what you might do in tadalafil and just give it. And you can't do it because you would then capture people where some would be lucky and others wouldn't. So you'd have an unacceptable risk. And that's what he's addressing at para 124. And we see it most clearly summed up in paragraph 125. The thing that's holding back the skilled team on this inventive step argument is the worry that administering a wide range of once-a-day daily doses would have posed a real risk of including one or more that missed the window. So what he's done is split the thing down into two. Question, would once a day be something that I think would work without knowing which particular one, because in other cases, if you think that, you just look at them. But then he said, but I can't do that looking at them, including the wide range, because of this particular point. It's the additional point that he's explaining, that you wouldn't administer a wide range of once-a-day doses because that would pose a real risk of including one or more that missed the window. And it really is important that you understand that that's why he's talking about wide range, because he's comparing the situation that you might follow in a case like tadalafil, because Mr. Wall was emphasising the difference. Now, of course, in this case, what he doesn't do, and what the experts didn't do, was say, well, I think once a day is going to work, so I'll have a wide range and I look. That's just not what our evidence was, and it's not the way the judge approached it when he actually concluded that it was obvious. But here he's explaining the argument as to why you couldn't do it this way. And just to skip ahead, he does, when he looks at his findings.
Yeah, so just putting that in a slightly different context. I mean, this case is a bit odd in one sense, because the claim is very odd for a number of reasons. But one of the oddities is it's got no limits on dose at all.
Exactly.
So it covers a vanishingly small amount administered one daily up to a huge amount administered one daily.
Yeah.
And so therefore you can understand an argument that would run along the lines of, well, almost any dose ranging study inevitably hits the claim. But that wasn't in fact the way you presented your case, because you accepted that in the real world, because of these risks, you would aim for a dose that was considered not to pose an unacceptable level of risk.
Exactly.
And that's how you end up at the 30 milligram.
Exactly. and we only put, well, Professor Hirsch had lower ones for the heparin reason, which was rejected, but the two that were coincident between our experts was 30 milligrams once a day. And to put it slightly a different way, my lord, the claim is just to the idea of once a day.
Yeah.
And so you can ask yourself the question, is once a day likely to work? And that's still a question. He is not saying it always would be considered as likely to work without reference to the evidence, which is the suggestion that I think they're making in criticising the first sentence. You can ask yourself, is once a day likely to work, and think yes. So there's no technical barrier in the ordinary sense in the cases, but you still couldn't do it because you don't know which ones to pick. And you can't do the normal thing of looking across a wide range. And that's the point he's making. You can't do that additional point. So you can come to the conclusion that once a day, as an idea, is likely to work, but then you have to actually know the specific one that does not introduce an unacceptable level of risk. And just to skip ahead, he does it in those two stages at the business end of the judgment. For your note, he concludes the skilled team would conclude that once-a-day dosing had reasonable prospects in paragraph 254, expressly leaving open whether the data indicate there was a dose which would be safe and effective. The paragraph that my friend said he didn't understand what he was doing because he suggested he was doing the same thing but then leaving it open. He's doing something quite different in that paragraph. He's finding reasonable prospects of success of once a day at the level of the claim, but recognising that this additional argument that had been run, that you couldn't actually even look for it unless you knew which one it was, to the level of not introducing an unacceptable risk. Yeah. And it's in paras 255 to 257 where he makes the finding on the second limb as to the specific 30 milligram once a day being perceived as not having caused an unacceptable level of risk. So putting that back in the context of the analysis my friend is criticising in 124, the first finding at 254 is the one he's foreshadowing as his view on the present case. The present case, he says, in the first sentence, there's no perceived technical barrier. In the sense the skilled team would perceive once a day dose would work. That's his conclusion, as we see at 254. And he's simply foreshadowing it in 124 to explain the nature of this additional point that Bayer is advancing. And the finding in 255 to 257 as to the skilled team's perception of the data indicating 30 milligrams once a day would not cause an unacceptable risk is the answer to the remainder. That ethical dimension, or we can just call it the concern of running an unacceptable safety risk, does not, on the judge's conclusions of fact, stop the inclusion of 30 milligrams once a day in phase 2, as Professor Hirsch and Wilkins had said it wouldn't. So he analyses the ethical extra issue, but it does not stop 30 milligrams once a day being adopted. And it's worth noting, my ladies and my lord, that those experts did exactly the same as the judge. Not only is the dose the same for each of them that the judge accepts, but they didn't take the approach of looking, saying, well, I think once a day will work. I've just got to look across the wide range. They didn't do that. They looked at the data and said, this one is one that I think you can reasonably adopt without an unacceptable risk. And they were following the same approach because this ethical dimension is part of how the skilled team approach things. One cannot take an unacceptable risk. But 30 milligrams once a day wasn't doing so in the opinion of Professors Wilkins and Hirsch, that the judge accepted. Now, the next passage of the judgment, paras 125 to the end of this section, is directed to the oddity in the case that one might suppose that Bayer's argument on obviousness was that the skilled team would not have included 30 milligrams once a day because of a perception it carried an unacceptable risk. But Bayer was prepared to do that. And he refers to ethical reasons, which we know from context what he means is unacceptable risk to patients. And the reference to the ethics committee comes in at para 127 because the oddity is not just Bayer taking the unacceptable risk. The unacceptable risk couldn't in fact have been taken because the ethics committee would stop that. And that's the point he's making at 127, where the point is made permission was granted, so presumably patient safety wasn't put at unacceptable risk. And there's nothing wrong with that observation in my submission. And in paras 128 to 130 of the judgment, the judge discusses whether the fact that this ethical question, that's the question of unacceptable risk to patient safety, will resolved by the ethics committee, is actually any different to simply the skilled team considering that there was a reasonable expectation that a once-a-day dose was both safe and efficacious. And para 128 is said by my friend to be suggesting that there was a reasonable expectation of success despite patients being put at unacceptable risk of harm. That's my friend's skeleton, para 38. With respect, the judge is saying precisely the opposite. He's saying even if one reasonably expects success, but showing it would involve an unacceptable risk of harm, there's no reasonable expectation of success within the meaning given to that criteria in patent law. Saying exactly the opposite. And he's right. We were both arguing what the skilled team would want to do as a phase 2 trial, what they would want to include, working within the parameters the team actually work in. That's what we were arguing. And actually, 130, the judge identifies that this way of putting the point and considering the ethics committee is, on one view, just amounting to the same thing as what the skilled team would do. And as I explained, when you look at that answer that we saw earlier, everyone's working to the same standards, the same requirement not to put patient safety at unacceptable risk. So he's right in that suggestion. It is just another way of putting what the skilled team would want to do. And crucially, as I've already said, and keep coming back, crucially, as the judge reiterated at para 245 later, it's exactly what he said he was doing at the key part of the judgment. I was going to move on to the second error, unless you've got anything you want to ask me on. The second error is the one that my friend has dealt with in writing but not orally. There does seem to be a bit of an overlap with the first, though. And the premise of the point seems to be to suggest that there's nothing in the harder posters to support once-a-day dosing but the statement in the conclusions. My ladies and my lords see that in para 43 of his skeleton, characterised as a single statement. And you understand, I hope, why we say that's kicking off on completely the wrong foot. And paragraph 45 of my friend's skeleton says the reasoning starts at 249 of the judgment. In my submission, it's plain from the judgment the reasoning doesn't start there. Not only are there important paragraphs leading up to that point, which he ignores, the paragraph said to be the start of the reasoning actually begins with the words, it follows that, to indicate that what's being said is part of a chain of reasoning from the immediately foregoing passages. And those earlier paragraphs are, first of all, para 247 that explain why the judge viewed the Bayer expert evidence as a counsel of despair. He also points out that the consequence of their view would be to abandon the idea of phase 2 altogether. that's the top of page 80 of the bundle, where the judge notes that the stance wasn't supported by Bayer's counsel. And as I've already flagged, the judge's view was that those experts had a determination to be negative. However, what my friend is actually doing is developing a point that's the same kind of point in disguise, complaining that the judge didn't contemplate that antithrombotic effect might be expected to be not sufficiently useful. And just to flag the point, we'll get to it, but of course that argument would be applicable to all and any dosing regimes, whatever their frequency, including their fallback position. That's the way the argument develops. Returning to the passages that Bayer skipped over in the judgment, there's also para 248, which records the judge's conclusion on the skilled team's perception of the advantages of once-a-day dosing. He'd concluded, not surprisingly, that once a day would have been known to have clinical advantages and financial potential. The end of 248 points out that even if that had not been at the forefront of their thinking before reading the art, where the art raised the possibility of phase 2 trial including a once-a-day regimen, that would have been given serious consideration. So that's all in the run-up, my ladies and my lord, to para 249. And the first thing the judge says, which he expressly says follows from what he just explained, was that the statement in Harder that some parameters investigated suggested suitability for once-a-day dosing would have been found to be both striking and encouraging. So that statement is in fact all about the desirability of the once-a-day and then seeing it flagged up expressly in the art. At this point, it's not yet about or even mentioning the status of the authors at all. It's following on from what he's just been talking about. Contrary to the impression given by my friend's paragraph 45. It's true the judge goes on to refer to the authors in making the point that follows, but that first bit, not so. And the following point is that the reader would consider carefully why the authors had put their name to the statement. In other words, they'd look at the body of data to understand how it had been thought appropriate to suggest it. In the last sentence of 249, the judge also points out that in the abstract version of the poster, I don't know whether my ladies and my lord have picked that up, they're all in a book. When you go into the conference, you get summaries of the posters in a book, so you know where to go to look. So they've in effect got a shortened version and then the posters that they look at. And the judge concluded that they would have read the abstracts as well. And he's referring here to the abstract version of Harder. And he's drawing attention to the statement there that it specifically points to a 24-hour effect after a single 30 milligram dose. So that's the last sentence of 249. My friend Skeleton continues with the criticism of this passage at 46, alleging that the findings are extraordinarily weak. And the first thing addressed is para 250 and 251 of the judgment, where the judge addresses the PK half-life data. And the thrust of these two paragraphs is, in the first, the judge addresses the three differing half-lives reported in Harder and the two Kubica posters, and discusses the relative weight that the skilled reader might think each have. And the judge expresses a view that the two Kubica half-lives would have been seen as more reliable. But that, of course, is expressed as a relative thing. And as my ladies and my lord know, half-life is just part of the picture anyway. Yet in my friend's Skeleton, he presents this argument as if this is a first past the post issue, and he wins all of the half-life share of the vote. That's the way he's presenting it. It's not that what the judge is doing at all. He's explaining that for half-life there are three different results, and as between them, the two Kubica ones would be seen as more reliable, But he's certainly not saying, forget about harder. He's just telling you what the relative weight as between the half-life data is. And he explains further in para 251 of the judgment. My friend criticises this paragraph of the judgment at 47 of his skeleton, suggesting the judge is explaining away the fact that the Kibitzer half-life was significantly shorter by going back to the authors, and he argues implicitly their status. My submission is this is not a fair reading of paragraph 251 at all. What the judge is talking about here is a point that my lord raised with my friend this morning. The authors of Harder overlap with Kibitzer authors. This is not a point about particular status. It's simply a point that the skilled team would know they're the same team with the same people, and they'd therefore be aware of the Kibitzer data. And I hope my ladies and my lord will recall Kibitzer comes first in time, and that the authors would be perceived as not likely pointing out the data supported once daily dosing if the data were to be dismissed as of no value because of other data. And in my submission, that is a perfectly fair point the judge is making. The authors are the same, or at least they overlap significantly, and the skilled reader would not approach this on the basis they would have made the claim they did if the data was to be dismissed. Now, the judge goes on in 252 and explains his view that the skilled team would therefore return to the PD data. And it's here that he embarks on the quite detailed analysis of what's seen in that data. Can my ladies and my lord look at the way my friend describes what the judge is turning to do at 252? According to my friend's skeleton at para 48, they say he's turning back to the PD data to have another go. That is a grotesque characterisation. He's not explained what the skilled team would get from looking at the PD data at all yet. All this intro is explaining is why they would turn to look at it. It's not in any sense going back to have another go at it. And the second sentence of para 48, my friend's skeleton, is also pretty outrageous. The argument is, we know already, of course, that the PD data actually referred to in Harder does not support once daily dosing either, contrary to the conclusion the judge came to, and we certainly don't know it already. This paragraph of my friend's skeleton refers to the fact that an effect was seen at 24 hours in the graph, something Professor Hirsch drew attention to. It was key in his view. We set out how he summed it up in cross-examination in paragraph 58 of our skeleton. The gist of that was that there was uncertainty as to the half-life data, but he could see the signal in the PD data, and that's all he needed. Paragraph 48 of my friend's skeleton seeks to justify paying no regard to this feature of the data by referring to statistical significance, but I've already covered that point. These tests, both the prior art and indeed the patent, can't aim to show results which can claim to be statistically significant. And just as an aside, be quite careful with the label error bars. It's a homely label, and we all know what they look like in graphs, but the crucial thing always is to understand the nature of what they're depicting, whether it's actually an error in a measurement or, in this case, a standard deviation. A standard deviation tells you what a spread of a population is and is not of itself an indication of anything dodgy about statistical significance. So you could have, for instance, a population of 10 that has a standard deviation of a particular size and a population of 1 million that has exactly the same standard deviation, the same spread, and overlapping standard deviations is not an issue as such. What really matters is the size of the population and the P number in these things, as I'm sure my lord has seen in other cases. So just as an aside, be very careful with reference to that in my friend's submission. Now, the argument proceeds at para 49 of my friend's at skeleton with the optimistic assertion that so far, therefore, on the judge's findings, there was no evidence to support once daily dosing. So far. And the suggestion is no evidence. Apart from, we say the following, the expressed harder statement. That one of the three half-lives, albeit not the one that would be seen as the most reliable, but one was in accordance with that. The allegation is no evidence at all. Apart from also the statement in the abstract, which is equivalent to harder, specific to the 30 milligram once a day, identifying an effect lasting 24 hours that the judge referred to at paragraph 249. Apart from the fact that some of the actual ETP data presented in harder graphically referred to in para 252. And apart from the perception that the judge explains that the skilled team would have from the fact that the authors are the same and would be unlikely to have made the claim if other data in Kibitzer meant data supporting once a day was to be dismissed. So apart from all that, no evidence. And of course, the judge has not yet turned to consider what the skilled team would get overall from the PD data. So we've got the figure 4 point that I flagged up as we went through and what you see in the Kibitzer posters. Now the rest of this section of my friend's skeleton seeks to build upon what we've just seen by suggesting that in 253 to 257 the judge's analysis of the underlying data and the evidence is missing the target. Those are the paragraphs where the judge makes findings that the skilled team would conclude that it was reasonable for the harder authors to have said that there was data in the harder and Kibitzer posters which suggested that Rivaroxaban was suitable for once a day. That's 254 that we looked at. And specifically that 30 milligrams once a day would be considered to have sufficiently sustained antithrombotic effect over 24 hours. That's the question he set up at 255 in the last sentence, and he's obviously answering in the affirmative by preferring Professor Hirsch and Wilkins' view at 256, holding that the risk of insufficient efficacy or excessive bleeding was not unacceptable. Of course, some risk is inevitable, but there's always risk. The question is whether it's unacceptable. And as I've said, that would be true of all doses in phase 2, whether it's once a day or twice a day. And the attack on these findings is a rehash of the point that one doesn't know for sure before doing the trials. We see that's the substance of what he's picked out in my friend's skeleton at 51. And now the way the point is sought to be put here is when talking about sufficient efficacy. So for example, the last sentence of para 256 of the judgment, when the judge refers to not being able to rule out the possibility of insufficient efficacy, they suggest he's not talking about efficacy in the sense of sufficient to be therapeutically useful. So for example, in para 50, we see it said, we don't know what the judge meant by effective here. In para 52, they complain the finding was not using the words sufficiently sustained useful antithrombotic effect over 24 hours. We just don't understand what it means to speak of efficacy that's not useful on this side of the court. And that's plainly what the judge is referring to when he's addressing efficacy. So we submit there's nothing in this criticism, and moreover, it's just another way to dress up their argument that one cannot know for sure before actually doing phase 2, something the judge rejected, and in fact they didn't even support in closing. And I'd add this, I asked rhetorically, how both of the 20 milligrams and 30 milligrams twice a day dosing, each proposed by Professor Myborn, how do they pass that test? Now,
is that it on your point, that particular point?
Yes, apart from the fact that on paragraph 52 he's muddled up the ribbon and therapeutic window, but I think that's it. I was going to do error 3 now.
Very well.
And this I can take much more quickly. There are 3 substantive paragraphs in the skeleton, 54 to 56. And it culminates in the submission at 57 that the judge made an error that fatally undermines his analysis. The complaint is the status he attributed to the authors of harder in the mind of the skilled team. That's what it's all about. Before I go any further, can I emphasise a point we made at paragraph 100 of our skeleton? And that's to emphasise the relevance of this to the judge's analysis. The relevance, the reputation of the harder authors in the eyes of the skilled team is a reason to consider what the basis was for the statement in the 4th bullet point. That's all it is. It's important to appreciate that what the judge didn't do is to hold that the skilled team would just take the statement without looking at the data and conclude the data supported it. It's simply a reason to actually look further. And we also say in paragraph 100, Professors Wilkins and Hirsch, who we preferred, didn't take it in that way either, as I'm just going to take it at face value without looking at the data. They looked at the data. But the thrust of my friend's argument has to be that without the status of the skilled team, the skilled team wouldn't have looked at the data, or at least not so carefully, not got to the stage that Professors Wilkins and Hirsch did in looking at it. And I also make the further point, that wasn't the approach of their experts either. They looked at it all extensively. They looked at all the material and sought to put forward a view on the basis of that exercise. You know that the judge's view was that they were determined to be negative, but it wasn't an exercise in saying you wouldn't bother to look at it. Both sides' experts actually did look at the underlying data. And all the judge did, in relying on the status of the authors, is to say, you'd look at what they'd said, and the status was part of the reason he said that you'd go on and look at the data. That's all it was. So ultimately, the point I'm making is ultimately, the conclusions the judge reached were based on his view of which side's expert evidence more closely corresponded to that which the skilled team would hold on the issue when the data was looked at. And the relevance of the author's reputation was no more than a reason that the skilled team would look at it. And of course, on any view, a team from Bayer, one of the world's leading pharmaceutical companies, together with people from the International Institute of Thrombosis and Vascular Diseases and Frankfurt University, is going to be viewed as a high caliber team, on any view. And that no doubt explains why not only did previous counsel not identify this as an issue when the application for permission was filed, despite filing a series of grounds where they were obviously seeking to re-argue issues of fact, where my lord refused them permission. They didn't see it there. And despite it being clearly flagged in our cross-examination and written closings, there was no submission in writing or oral closing from the other side at trial that this was wrong, that they wouldn't be seen as a top caliber team. And the substance of the judge's finding is just that. They would be considered high caliber scientists working in leading institutions, including Bayer itself as a leading pharmaceutical company. That's the substance of it. And in my submission, any attempt to disturb that is bound to fail. And I might add, certainly any attempt to suggest that the judge was not justified in holding the view that the reputation of the authors collectively in the mind of the skilled team would not have justified looking closely at the data, which is the point that matters, to see the support for the statement in the 4th bullet point, is also bound to fail. Now, the essence of the complaint now made seems to be the judge expressed himself in a way that could be understood as concluding all the authors each had a preeminent personal reputation independent of each other and the institutions they were in. That's really the essence of the claim, the complaint. They're not actually looking at the substance of it. And even that is justified for some of them, as we identify in paragraph 103 of our skeleton. It is perhaps most obvious for Professor Breddon, singled out by Professor Hirsch in his evidence to be very well known as an academic clinician.
And will you set all this out in your skeleton?
Yeah, I do. So, my ladies, I don't think I've got anything to add to what I've written in writing on ground 3.
So, ground 4?
Ground 4, the invention story. Well, I can speed this up. Because one of the short answers is the judge had already decided it was obvious before he even turned to it. Because the argument relates to what the judge said in 259 to 260. And actually, what this related to was an oddity of Bayer, in fact, taking forward what they say would be considered to be unsafe. But the judge had already concluded, before he turned to it, you can see that clearly from 258, where he expresses the conclusion he'd reached out of obviousness, and then begins at para 259, so that's the foot of page 81, with the clear words, that's sufficient for me to reach the conclusion on inventive step over harder and the Kapitza poses. And then he went on in the next sentence and said, I would add. So it's clearly not part of what's necessarily part of his reasons. So that's the short answer.
Is the longer answer contained in your skeleton?
It is.
Right.
I'm getting the message, my lady. I don't think I've got anything to add to what I've got in the skeleton about the longer answer.
Sure, no. Anything else?
I don't think so.
Thank you very much indeed. Anyone want to follow?
Can I, I'll begin with the first ground of appeal, the paragraph 124 to 125 point, what Malone friend said about that. As I understood Malone friend's explanation for the passages that we've complained about here, he says what the judge is actually doing is giving a sneak preview of his findings on the evidence, which we find later, 130 odd paragraphs on. We submit that that is plainly not the case on a sensible reading of this passage that starts at 123 during my reading trial, and makes various statements about that, and then immediately follows on to 124. There is no suggestion that this is anything more than the thought process that the judge had been through and the conclusions that he had drawn before the trial had begun. And therefore we submit it can't possibly be seen as some kind of taster of his final decision, which of course explains why, when we look at his reasoning towards the end, he comes back to this touchstone of the ethics committee, which this analysis sets up in the first place. The judgment is internally consistent from that point of view. And we say that Malone friend's reading of paragraph 124, which I didn't quite understand, isn't what is clearly there. It's a perfectly self-consistent paragraph. The judge kicks off by announcing that there's no perceived technical barrier. And then he gives the reasons for that conclusion. Having found there's no perceived technical barrier, all the technical issues on likelihood of success inherently fall away. And what he's saying in the...
But in that case, he could have stopped the judgment there.
Um,
So why did he go on to repeatedly ask himself, on your submission, whether there was a reasonable expectation of success?
because what he was asking was not, is there a reasonable expectation of technical success? That's to say that a single dosage will fall within the window. But I know that it is going to fall within the window. Something is going to fall within the window. There is going to be a single dosage that works. Can I persuade the ethics committee to let me carry out a series of experiments on multiple different single doses till I find the one that works? I mean, that's what he has said in these passages is the actual test. And that's exactly what 124 and 125 say. And that's why he has to go on to look at it. But we say what he's going on to look at is completely the wrong test. Essentially, he's just going on to find a dosage that he can get through the ethics committee. But he knows in advance that that something is likely to succeed. And we say that finding there, such a range would have been likely to find the therapeutic window somewhere. I know the friend doesn't even attempt to defend that as a proposition in his skeleton argument, and it's plainly not the case. Lord Justice Arnold is right that the claim is broad, and of course that means you can have very large dosages, but that doesn't solve the problem, because if you have a very large dosage, thus guaranteeing perhaps that you might still have enough effect at the end of the 24 hours, you've got an excessive amount to start with, and you've exceeded the top of the therapeutic window, just as we see in the graph at 176. So it doesn't resolve the problem in this case, the breadth of the claim. And of course, what the judge then goes on to do in 243 to 244 is look at the ethics committee and say, well, what sort of position do they take on this kind of thing? And then, off the back of no evidence, makes various findings that they would take a very generous approach, because there have been other tests, other trials carried out where volunteers have unfortunately died. So we say quite plain that he's just got the whole thing wrong. Can I look now at what's said about my comments on Professor Hirsch's evidence and the judge's findings on those at 165 to 167? And the suggestion was made that this was some kind of really an extra ground of appeal, and my submission plainly not. My point was simply this: based solely on the judgment, the judge has himself undermined the evidence of Professor Hirsch on the key point. So when we get to the rather Delphic passage we submit in 257, which appears to be the ultimate conclusion of obviousness, you can't simply be saying, I accept Professor Hirsch. There must
Equally,
be reasons.
You don't have a ground of appeal, that there's no adequate reasons.
Well, no, what we say is we know how he gets to this finding, which is the main error and errors which we've identified. But what we're saying is what the judge isn't doing here. We're almost anticipating a point that might be made against us, and I think at some points my learned friend was trying to make against it. But all the judge is saying here is, Professor Hirsch says that it's an obvious thing to do, therefore I accept that is the case. And we say that doesn't stand if that is what's being pushed with his findings in 165 to 167. My learned friend had some specific points about that, effectively saying that Professor Hirsch's reliance on the inadmissible data was limited to a single point on a 5 milligram dosage. We say that's clearly not the case. First of all, the point that he makes about the heparins and the low molecular weight heparins, in which the judge deals with in 165 through to 166, was in fact relied on by Professor Hirsch generally in his reply report. I won't take you to it, but it's at supplementary 13, page 130.1 paragraph 30, he relies on it heavily as a general proposition against the evidence on which he's commenting, which I think was Professor Crowther. Yeah. And secondly, of course, even as Mr. Speck himself accepts, at paragraph 167, Professor Hirsch was saying that the factor 10A data, which the judge also excludes as not being part of the common general knowledge, supported a wide window. See the judgment there. And of course, he needs that wide window to justify his belief that there's no real risk of undershooting the dosage so that we're going to put volunteers at risk. The learned friend spent some time at the beginning of his speech on the point about the graph at 170, the ribbon and therapeutic window, and his reliance on X5, which is reproduced, or some part of it. Yeah, it's reproduced at 173. Now, as I understand it, he's essentially saying that for any given dose, given twice daily, there will be the same dose that you can give once daily, which will be just as likely to work because the ribbon is as narrow, but it will be at a different place and more likely to miss the window at the bottom end. Now, he did put that argument to Professor Maibaum, though I'm not sure, looking at it, that Professor Maibaum accepted it. But to be clear, Professor Maibaum's view, as expressed in his reports and in Cross, was that you would adopt a twice-daily strategy, and then you could gradually increase the doses. That's the safe way to approach the case. In fact, he said we'd start with 20. You'd only go to 30 if you had to. And that's T5, which is in the bundle, I think it's tab 13, 722, line 16 to 20. And we say that approach of going with twice daily rather than playing around with single or double dosages would have been the approach taken in the art. I mean, one can see that from the judgment in a number of respects. First of all, on half-lives at 162. And the idea that you follow half-lives is completely inconsistent with the idea that for any rate of dosage, you can just adopt a single dosage with an equal chance of success. Why are you bothering to look at the half-lives and follow those as giving you the frequency of dosage at all? Is also inconsistent with the judge's finding of fact, not appealed, in paragraph 176. We say it's not even consistent with what we find in the prior art, because of course Kibitzer and Harder address the question of dosage on the basis of frequency, not on the basis of actual amounts. They're talking about the utility of twice daily dosage and the possibility of once daily dosage, respectively. Again, following the way the judge looked at it, that this was, in fact, the approach taken in the art. And it makes sense. You don't want to overdose. You don't want to give a very high dosage. But if you don't give a very high dosage, and you know you've got a short half-life, there's an obvious risk in all cases that you're going to run out of protection. You're going to slip below the bottom end of the window. And that's why the textbook says you should use frequent dosage in such cases. And we say that's why the judge made the finding he did at 176. Can I look briefly at the eminence of the author's point? I think what my learned friend did was not seek to defend the actual findings that the judge makes. I think it must accept that what the judge says about the authors is in point of fact incorrect. And what he did was he created a sort of thrust of what the judge is saying, which downplayed in our submission what the judge actually says about the authors. So what we find in the judgment is not simply a statement that, well, Bayer is a well-known company and the authors are a reasonably high caliber. We get much more than that. We get specific reference to Dr. Harder, who's the lead author, as a distinguished clinician of apparently international renown. Not the case. We get a specific reference to Misselwitz being a senior figure, not known to the skilled person. And we get a reference to Bayer being a leader in the field, not merely a pharmaceutical company. So, my learned friend's right, there is a characterization generally here, but it's a much higher characterization of the caliber and reliability, fame, renown, eminence of the authors than the one that my learned friend sought to suggest. And we say the only reason the judge is doing that, or referring to that, is that he thinks it is important. And he pitches it at that level, because at that level it could be said that it did have significance. And it's impossible to conceive that the judge would have gone to this trouble if he hadn't thought that it was something which played a significant part in the argument. And of course, when one looks at the way these points were flagged in cross-examination and in closing, one could see that that was precisely the intention of the defendants to give that impression. But we say it does therefore undermine the decision. If the judge has relied on it, if it's a way overstatement of reality, then the judge has relied on matters on which he should not have relied, and his findings at that point become undermined by material considerations. I think my learned friend, at your encouragement, fell back on his skeleton argument on a couple of the other points, and I won't address those any further because you have my submissions already equally on those points. There may be one final point that I wanted to make, which is about the interrelationship of the Harder and Kubica authors. It really arose, I think, more out of my Lord Justice Arnold's comments, but it was picked up to some extent, I think, by my own friend. Because he relied, I think, on the abstract, and the abstract, which is also part of the package of documents on which the judge said the skilled person would rely. There was some evidence about these posters and how this poster abstract thing all works at trial. Posters are not peer-reviewed documents. I think there was evidence they could be sort of rushed into the hall and very quickly stuck up. Perhaps no one else other than the authors has ever seen them. And then they're removed at the end, whereas the abstracts remain as published material. The abstracts are, at least in part, peer-reviewed because they have to get read by, and someone has to decide that it's appropriate to put them in the publication. So what we have here is Kubica that says no more than twice daily. They had the complete data. They tested far more individuals. They're good half-life data according to the judge. And they didn't say it was indicative of once daily. The suggestion appears in Harder, but the poster doesn't appear in the Harder abstract. a suggestion of suitable for one's daily dosage. We don't know why. And we don't know why the difference. The harder document obviously was research carried out on far, far fewer people and had distinct statistical issues. But maybe it was Dr. Harder who is the difference in the authors. He wasn't an author.
Professor Brennan, because he wasn't an author of Kibitz.
He wasn't, no. So
he seems to have been the most eminent of the contributors.
well, according to the judge. But in fact, he was, yes, I think, shown to be no more than a researcher at the Institute. He was the lead author. Maybe it was his idea, and maybe that's why. But given he wasn't an eminent author, not an awful lot turns on it. What we say is the fact that there's some overlap in authors doesn't add weight to a bullet point that only appears in one of the publications and not the others, if anything, the opposite. The change in authors may in fact explain it, and we don't know the history that lay behind this slightly unusual publication saga. Ladies and Lord, I think I've come to the end of what I wanted to say in reply.
Thank you very much indeed. We're going to rise. Oh, I'm so sorry, Mr. Speck, you're going to say something.
I was only going to confirm my client's thanks for organising this appeal so quickly. Because it's been,
Well, we are conscious, and we're grateful to my Lord, because it was he who brought it on as swiftly as it has been brought. And I know, and we know, how much work this has involved for all, for which we are profoundly grateful. What we're going to do now is rise. We'll certainly be out for about 10 minutes if anyone wants to wander or anything like that, and then we're going to come back in.
All right.
Yeah, exactly.
If we don't ask for it to continue.
In the phone,
Yeah.
the most interesting thing. Your phone
Well, in the highly unlikely event.
But then, you know, it always comes back.
The revocation because obviously, you know, obviously until we get to judgment.
Yeah,
think the only thing is the stay of the revocation, so that the appeal doesn't become nugatory. Sorry?
Well, whatever. Anyway, I just thought I'd indicate.
No. Oh, right.
Fine. I mean, they won't have it very long.
I think those are hand in hand. No idea of staying revocation.
It's not hard deadline. You can't do it for respect.
Yeah, I know. Just put it on the record. Put it on the transcript.
Can't be bothered.
When they've already done it.
Okay. Wait until
Nobody seems to bother.
just spend some time coughing the argument.
Yeah.
Okay, yeah. So we just.
That'll be fine. Anyway, no one.
Yeah. Absolutely. There's got to be some price.
Sorry?
Say it quietly.
It worked on well.
Which mic is it? That one.
Yes, sir. In the morning. Yeah, that's the name.
Sounds like an absolute money man. When we come, we've got Bayer and Brother Church. He's going to follow up. Just do a cartwheel.
No more jobs. One of the
party's
because all your people. Yeah, no, sure. No, no, certainly will. But you may want to react. It's what? So then type it up. Send it to her. It's what? Still on TV.
I've never. In that case, I
They knew they wanted to write this.
that was a miscarriage of justice. It wasn't a miscarriage of justice. There's no phones where a person like
Yeah. You could hear the fire. Oh, they're ready.
nice touch. Up on the left, we're going to measure it.
Thanks for bringing it up.
Also, just funny, isn't it? I mean, I can see that, you know, it's on both sides. And I can recognise that. Yeah. Yeah. Well, no, I mean, in this instance, it's actually accurate. Fully justified. It's more general.
All rise.
Mr. Purvis, Mr. Speck, as I said before we left, we are extremely grateful for the detailed submissions which have been made both in writing and in court today. The determination of the court is that the appeal is dismissed. The reasons will be given in a judgment which will follow.
Well, yeah, I'm very grateful. A couple of matters do arise from that. My clients are under an injunction currently,
Yep.
Which I think my friend accepts must go now.
Yep.
And I think he also accepts that I'm entitled for the clients that I represent here today to ask for an inquiry on the cross undertaking. I think those are the urgent things. Obviously there'll be a matter of cost, but
That can be
That
dealt
can
with
be,
in
yes.
writing, and
Yeah.
it may be easier to deal with that once you get our reasons.
Indeed. But I just wanted to be absolutely clear, there's no injunction now.
My suggestion was going to be that the injunction is lifted immediately, but all other matters, including cross-undertakings, financial things, stay of revocation, which I'm going to ask your lordship, my ladies, to do as and when we get the formal judgment, or may do, should be left over until after the judgment is formally handed down, when we can seek to agree an order, and if not, make submissions in writing.
Yes, I mean, Mr. Specker, is there any urgency about dealing with anything else other than the injunction?
No urgency. I mean, the cross undertaking, I can't see that there's any issue on that.
Well,
But there's no urgency.
it may be that they want to think about it. I mean, at the moment, then you can't see anything, but who knows what might arise once they've had a chance to think about
There's
it.
certainly no urgency.
Yes, that, to avoid any controversy about it, we've got a stay of the revocation of the patent until the hearing of the appeal, I think.
Well, we can continue the stay of revocation, because again, that's not urgent. The only question of urgency is the injunction.
We will, I'm sure, draft up an order to that effect, and then we will wait for the
Yes,
handout.
yes. For the sake of good order,
Further
I think
debate.
that would be very helpful. Thank you.
Right.
Very good.
As you know, and it probably doesn't need saying, the judgment, when it is drafted, will be sent out to the parties. You will be well aware of the authority of Counsel General in Wales and the issue of the embargo and contempt. All we invite are amendments of any typos, no re-argument, please. Thank you all very much indeed, and we are conscious it isn't just the front row who's done a great deal of work on this case, it's a lot of other people in this courtroom too. Thank you.
Court rise.
I suppose that's right. I was thinking if we were to interpret things out of there. Depends how you interpret it.
This is one of